plea in a sentencing on a 40-count possession of child pornography. At the sentencing hearing, the attorney representing the defendant presented a copious amount of evidence from the defendant's family members, approximately 25, as well as testimony from a certified psychologist, Dr. Renier. The court has two issues before it. The first one is whether or not the trial court erred when it found it did not have a valid basis to depart from the Florida sentencing guidelines. And the second issue, which is whether or not the Eighth Amendment was violated by the gross disproportionality to the sentence.
Can I ask you a question about the first issue?
Yes, sir.
Make sure I understand your argument. Your argument is that the trial court erred in misperceiving that there was a valid basis. Isn't it possible from the record to infer a different rationale? For instance, on page 90 of the record, the trial court said, it appears that maybe you have had a very harsh upbringing, but nothing was ever disclosed to validate a basis for post-traumatic stress disorder. And the trial court made an evidentiary judgment based on the credibility of all the witnesses and decided there wasn't a malady that fit the bill for the downward departure.
No, Judge Atkinson. Specifically on page 90 and 91 of the record, where the court makes its findings, the court says there wasn't a valid basis for departure because in order for there to be a valid departure, there's got to be a legal ground, which in this case is 921.0026 sub 2 sub D, which is that the defendant has a mental disorder or defect, which is what that comment goes to. Specifically, Dr. Renier makes a finding on the record that there was a mental disease or defect.
And why do we have to, don't we defer to the trial court's assessment of the evidence presented to him or her?
In terms of credibility, yes. In this particular case, the trial court found that Dr. Renier did a competent and thorough job. This court has specifically held in Williams versus State, when there is a psychologist who the court deems to be credible, that's sufficient for competent substantial evidence. Part of the
sufficient, meaning in the case in which, perhaps the state is contending that the downward part was incorrect. In that case, what was the posture? Was it the state appeal or was it?
It was a defense appeal in that case. It was a defense appeal in that case. It was a case from this particular court. It also involved Dr. Renier, I believe, or that was the Jeske case, one of the two, that Judge Morris authored. Now, specifically, the issue we have here, and the court reviews it under the Barnhill case, which this court issued in 2014, is whether or not there's a sufficient legal ground, number one, which was specifically alleged in the motion and argued by trial counsel. And then number two, whether there was adequate factual support for that ground.
Let's talk about factual support.
Certainly.
Okay. And there's testimony from the doctor that says that, well, one of the requirements is that the defendant has to be amenable to treatment.
Correct.
Okay. And the doctor says, I think he'll be amenable to treatment because of all these, because this event has brought him and his family together. Okay, short summary. But then he also says that the defendant doesn't want to undergo any sort of therapy. So isn't there a conflict on that prong of the legal basis, whether or not there was factual support for that ground? I realize it's addressed in the motion.
And Judge Smith, there's absolutely adequate factual support for that ground.
Okay. What does amenable mean then? Back me up here and tell me what does amenable mean.
Amenable means that treatment would be successful. On the one hand, Dr. Renier said that Mr. Maniak, based on his upbringing in the Ukraine, had a different response to therapy because therapy in the Ukraine means something different totally than it does here in the United States. He further said that in the record I cite, especially in my reply brief, that based on some education that Mr. Maniac would receive and acknowledging, as he did throughout Dr. Renier's evaluation, that he was extremely remorseful for what happened, that coupled with educating Mr. Maniac about treatment and things of that nature.
But then does he wrap it up and say, after we had that discussion and he understands what is different in the states, that he agreed that he would go into therapy? Because I'm having a hard time finding that someone who refuses treatment would be amenable to treatment.
Dr. Renier specifically said that those type of individuals are actually more responsive to treatment. That's
Okay, those types of individuals, we're talking about one specific individual here.
correct. And Dr. Renier on page 54 through 56 of the record on appeal makes that conclusion, or at least that's what I would argue to the court. So
I think he says, I think. I mean, if that's an opinion, I think.
he says ultimately that he should be amenable to treatment, and people like Mr. Maniac, who are initially unresponsive to treatment based on some psychoeducation, actually do the best and benefit the most from treatment. I would submit to Judge Smith that that's sufficient to find that there was amenability to
You
treatment.
mentioned the word sufficient frequently, and I want to just understand your
Certainly.
conception of the nature of our review. If the record is sufficient to support an evidentiary basis for downward departure, but the trial court properly perceived that this is a departure ground enumerated in the statute, but aren't we to show some deference if the trial court, even under sufficient evidence, decides that there is not, that it's not supported, that there is not a ground?
The court under Barnhill, this court, is required to review specifically whether or not the defense presented adequate evidence, factual evidence by preponderance of the evidence, that there was a sufficient ground presented.
So in other words, you must be saying then that if we find that there was preponderance of evidence and the trial court did not downward depart, then therefore ipso facto a reversal.
I would submit there's an ipso facto for reversal, not necessarily that the court specifically says you've got to grant this downward departure.
Because the trial court's not required to grant.
Exactly.
It's discretionary.
It's discretionary, but we never
So
got
why can't, from this record, we see that the trial court decided to exercise that discretion and decline to downward depart?
because there's absolutely nothing in the record to say that the judge got to step two, even from the comments that she made. On page 91 of this record, the court is specifically clear and responds to the state attorney's argument and says, I don't find there's a valid basis for departure. When the unrebutted evidence was presented by the defense to the court by a confirmed, effective psychologist, there was nothing in the record to suggest that she totally rejected his testimony. There's a litany of cases, not only from this court, but from other district courts of appeal, where the trial judges will say during a motion for downward departure, well, I don't think you proved a basis. And even if you did prove a basis, I'm going to exercise my discretion and choose not to depart. We didn't even get to step two.
So let's presume for the sake of discussion that the second prong wasn't reached. Under Barnhill, it says, first the court must determine whether it can depart, whether there's a valid legal ground and adequate factual support. Legal grounds are set forth in case of law, and the facts must be proved by preponderance of the evidence. And then it goes on to talk about the standard review. It's competent substantial evidence. In whether the scenario, if the fact finder has to find something by preponderance of evidence and there is a sufficient basis, but there's potentially countervailing evidence, that do we decide that if there just could have been a preponderance, therefore we must reverse?
Judge Atkinson, what the law specifically says in this case, and the case law from this court and from other district courts of appeal, specifically Daniels, Hunter, and Geraldo, which I cite in my initial and reply brief, if a defendant presents unrebutted evidence from a licensed psychologist, and there's not specific notation in the record that the trial court rejected that psychologist's testimony, that in of itself is sufficient to meet the first prong.
Sufficient.
Correct. Correct.
Okay, sufficient, but in many circumstances, this court reviews a record with sufficient evidence and still defers to the fact finder when the fact finder doesn't find the fact that the appellant wants it to be found.
Correct, but when the court is under a misinterpretation of the evidence or is confused about whether it can or will depart, that is specifically something.
That's a separate question, and you have an argument for that, I'm sure.
I do.
Whether it was confused, but sticking to the factual one, why don't you explain to us why there's not competent substantial evidence to support that there was not an evidentiary basis for the number of arguments?
I again would refer this court to the Williams case, which is found at 286 Southern 3rd 892, which specifically involved Dr. Renier, the exact same doctor that we're relying upon here, as well as the Jeske case, which again Judge Morris authored, which is 378 Southern 3rd 1199.
So if that it can be competent substantial evidence to support a downward departure.
Correct.
But is it possible that what we're reviewing is whether there's competent substantial evidence that the expert didn't support the ground? In other words, is it possible that this court can sometimes encounter a record in which there's competent substantial evidence for one side, but also competent substantial evidence for the other side, and the trial court or the finder of fact made a judgment call on the evidence?
Sure, but that's not what we have here.
Okay, so why not?
You don't have that here because you have a licensed psychologist who presents completely unrebutted testimony, okay, which is what the Williams case talks to and speaks to exactly. Unrebutted testimony, there's not a rejection of the psychologist's testimony from the trial court. Again, the first ground must be a legal ground, which is supported here in this particular case under the statute, and there's got to be adequate factual support of the ground. We have that here. What the trial court cannot do is say, I don't have a valid basis, when there is in fact a legal basis for the court to depart based on the case law. I would also submit that.
How do we know, I mean, the court didn't say, I don't have a valid legal basis. How do we know that when the court was saying, I don't have a valid basis, is that the court doesn't have a valid basis in its discretionary review to downward depart, to choose to downward depart?
Because, Judge Smith, the decision of whether to downward depart is a two-step process. The discretion that you're referring to is whether or not the judge should depart. That is not clear from this record.
And so at the very least, then, are you arguing that we should remand back for the court to clarify what they meant, what the court meant when it said, I don't have a valid reason to depart? I'm
asking the court to reverse and remand for a new sentencing hearing because the court appeared to misconstrue its ability to depart based on the statements it made. On page 91 of the record, the court specifically said there's not a valid basis for departure. There was, according to the case law and the evidence presented in the case law from this court that I've cited within the brief.
Would you agree with me that the defendant did not provide factual support for each of the three criteria, that there would not be a valid basis?
No, I would not agree with that.
Okay.
The three bases specifically under 921, subsection 2D, which is alleged in this case, where there was a mental disease or defect. On page 49.
Assume for me, when we were discussing the amenable discussion that we had, assume for me that was not met. Would there be a valid basis to depart if they failed to show that he was not amenable to treatment?
If a defendant did not present one of the three specific criteria, that is definitely something for the court to consider and for this court to consider, because you have to present evidence of those three prongs.
But that's what I'm at. That's
you do.
My question to you.
You do.
So is there no valid basis to depart if someone fails to show that the defendant was not amenable to treatment?
Correct. Yes.
Okay, so.
You're right on 15 minutes.
If I can just answer the question and then I'll move on. Yes, Judge Morris.
Use any way you want.
Okay, so if they failed to show that the defendant was amenable to treatment, then there would be no valid basis to downward depart.
That is correct.
Okay.
I respectfully submit that that did not happen in the case. It's not argued by the prosecutor during the closing argument. It's not argued specifically and found by the trial court. So Judge Smith, I'd submit that that could not be a reason for rejecting the downward departure, especially when Dr. Renier said that Mr. Maniac was indeed amenable to treatment. I reserve the balance.
Okay. You have 5 minutes when you come back.
Yes.
I warned you a few minutes before,
Thank you, Judge.
seconds before. But when you come back, I'm hoping you will touch on Solon versus Helm and your disproportionality argument. You never got a chance to get there,
Yes, sir.
and I'm very interested in that.
Yes.
Yes, sir.
Good morning, Your Honors. May it please the court. My name is James Hellickson, and I represent the appellee of the state of Florida in this matter. As Your Honors are aware, Mr. Maniac was charged with 40 counts of possessing child pornography. Under the reclassification, they were secondary felonies punishable by up to 15 years in prison. In this case, the trial court imposed a legal sentence, which was the lowest permissible sentence. In this case, the lowest permissible sentence actually exceeded the statutory maximum, and if the court was not going to depart from the Criminal Punishment Code, or CPC, it had to impose that sentence. I would submit to the court that the trial court applied the correct rule of law. There was factual support for its rulings.
Mr. Hellickson,
Yes, Your Honor.
Mr. Hellickson, you heard the questions from
Correct.
Judge Atkinson and Judge Smith.
Yes, Your Honor.
And I was listening carefully to them too, because they were asking questions that I had, so
Sure.
I didn't have to work because they were doing it for me.
Of course.
But I am curious, I know what your answer will be, but I'd like you to articulate. Was the court's order and findings, were they adequate so that the record was made about how and why the court decided the way it did? It doesn't seem like it to me.
I believe it did, Your Honor, because if you look at his entire, Dr. Renier's entire testimony, there were some concerns that he had about the ability that he was amenable to treatment, for instance. And if you look at his testimony, there are things that Mr. Maniac did not report to him, or maybe he indicated that he wasn't necessarily being truthful, like he downplayed the sexual arousal part of the pictures. Dr. Renier said, you know, he's not reporting that these pictures arouse him, but why is he continuing to look at them for years and years? And if you look on,
Well, you had a psychologist basically say that I've evaluated him, and I find that he's got these issues, and that he's amenable to treatment. So it clearly would seem to me that that testimony would meet the requirements of that there was a basis to downward depart. Then the court's order was kind of vague on that. It was hard for me to really tell whether the court was deciding it didn't have a basis or was going to the second prong and saying, I choose not to exercise my discretion to depart. It wasn't clear to me how the court was ruling, and help me with that. Was it clear to you?
well, I thought it was, Your Honor. You know, it was clear that he understood, you know, what was going on at the departure hearing, that he had that he could have departed if he chose to. And, you know, the trial court says, you know, he read the court file, he saw the descriptions, so he's clearly considering, you know, the evidence in this case. And then he mentioned that,
But it's unrebutted testimony of a psychologist whose credibility was not assailed in any way. Right?
well, correct, except for the extent that his, you know, reports do show that maybe he wasn't necessarily amenable to treatment. Like, for instance, he denied being depressed. That's on page 49 of the record. So, and he said that he was not crazy. But then, you know, once Dr. Renier continued to probe, you know, he mentioned that he was, you know, depressed and suffered from depression and anxiety and panic attacks. And that, but he didn't, Mr. Maniac did not necessarily believe in treatment. So he wasn't necessarily sure that he would necessarily benefit from any therapy. So I think
Can you point to the record where it indicates the expert was not sure?
yeah, it's on pages 49 through 50. I believe it might be through 53 of the record. I know on page 53, he said that Mr. Maniac was defensive about his sexuality And, he was, he says on page 50 of the record that he would likely comply with therapy, but likely would not learn any lessons from it because he doesn't believe in the American, institution of that sort of treatment.
So even if we accept what I believe you're saying, which the evidence was equivocal, or even going as far as what I was saying, there could be conflict substantial on both sides. What Judge Morris was also honing in on is the trial court's rationale. What do you think we should, or we're able to glean from those two statements that I led off with, which is that it appears that maybe you have had a very harsh upbringing, but nothing was ever disclosed to validate a basis for post-traumatic stress disorder, and then moments later, at this time, I don't find that there's a valid basis for the downward departure.
And I think that's exactly correct, Your Honor, because there was no basis to include post-traumatic stress disorder, and it was questionable whether he was amenable to treatment.
What about other maladies?
Like depression, anxiety, all the other things that were clearly identified.
I think, again, it goes to was he going to be amenable to treatment? Would he get anything out of the treatment?
The trial court didn't mention that, and or did he or she mention amenability in the trial court's expression of its rationale for why there was no quote valid basis for downward departure?
Correct. I think it made just more of a generalized statement. So
you said general statement. Right. You're familiar with cases in which appellate courts, as Judge Morris alluded to, reverse because it's unclear. And is that, why shouldn't we do that?
Well, I think that what I was going to clarify, if I may clarify, Your Honor. So the statement is in this case, Dr. Rainey did a very thorough, comprehensive job in evaluating you, and there were some concerns that the court's seen. It appears maybe you've had a very harsh upbringing, as you mentioned, but nothing was ever disclosed to validate a basis for post-traumatic stress disorder. On the sexual adjustment inventory, your truth levels reflect that you were defensive and minimized this offense. I know I've heard.
Mr. Hudson, we wouldn't be here at all, even discussing this issue, if this trial court would have said that based on the evidence before me, there is clearly a basis to depart, and then go to second prong and say, but I choose not to in this case, right? We wouldn't be having this conversation, would we?
It would definitely be more clear, Your Honor. I can't really say that we wouldn't be having it, but I definitely think that, if they use those magic words, it definitely, I think under the two-prong standard, it will definitely lead the court to at least maybe a more clear conclusion that it hit both prongs.
But this defendant got 45 years.
Correct.
Which is a lot of time on a hazy record where the five of us can't seem to figure out what this trial court ruled. We're all asking questions because we can't figure it out. You guys are both trying to answer the questions, and neither one of you really convincingly have demonstrated that you could figure it out. So it's vague, right? Shouldn't it be, on 45 years, shouldn't it be real clear?
I get walk-up music?
Sorry.
I thought maybe we were going to go disco or something like that. Maybe that would help you, maybe that would convince you a little more, but no, I think, going back to, I think when you're considering, about, departures, and especially under the step one analysis, if you look at this court's decision in Jeske, there is a harmless error component to it, which is, if you can determine based on, I think, the offense level that the court.
Harmless error, 45 years?
Well, I think it goes to, can you determine that it was not going to depart, it was not going to exercise its discretion regardless of.
But see, here's what Barnhill really spoke to. Barnhill really spoke to the judge that basically says, I ain't doing it no matter what.
Correct.
And on this record, you could almost come to that conclusion. You have a psychologist basically saying, this is what's wrong with him. He's amenable to treatment, clear basis to depart.
Mm-hmm.
You got a court basically not really telling us, what its ruling is, but basically, I guess saying, I don't think there's a basis. I can almost conclude from this record that there would never be a basis for this court to depart. Like in Barnhill. You know, I mean, that's the concern of a vague record and a vague order. The judge hasn't been really clear about, I'm not gonna depart and this is why. We don't have that here. In Barnhill, we sort of had the same kind of stuff. I'm not gonna depart because I don't think I should ever depart in these kind of cases.
Yes, Your Honor, and I respectfully disagree with something with Barnhill in one respect with that. I think Barnhill didn't necessarily misapply the Banks test. I think Barnhill misapplied the statute, because I think that Barnhill, what the court should have said was not that we're going to apply Banks, but that the trial court's decision to issue that blanket, I'm not going to depart under any circumstances, misconstrued section 921, decimal 002, subsection 3, because under that subsection, it says a trial court may depart when there are facts and circumstances that show a legal basis to depart under section 921, decimal 0026. And so I think had the court said that, you know, the court misapplied the statute and not Banks, I think it would have made maybe the decision a little more clear. I think this court did clear that up a little bit more in its Jeske decision, where it specified, you know, what, like the proper steps. You have a facially sufficient motion for downward departure. You then move into the two-pronged test about determining whether there's a valid legal basis to depart and if it exercises discretion, because you have to, one thing that I think gets overlooked with Banks, and I want to point this out, is that in Banks, the court was not dealing with a situation where there was not a downward departure. Banks was a situation where the trial court downward departed, and they were looking to validate the downward departure. And in doing so, they said, look, if the trial court is going to downward depart, you have to have written reasons. And in order to have those written reasons, you have to follow two steps. If you do not follow those two steps, a downward departure is improper, and you should follow this criminal punishment code sentencing. And so I would submit to the court that Banks is not necessarily what you look at in a denial of a downward departure. I think you apply Banks when you downward depart and you're looking to justify the downward departure with the written reasons. What's that? Banks was, correct. And they were looking, the state was appealing the imposition of the downward departure. And so I think that when and the other thing with all due respect, Your Honor, with respect to Banks, is that dealt with the old sentencing guidelines. And I truly believe that when it migrated to the criminal punishment code, there were some things that got lost, because when you're dealing with a criminal punishment code sentence, it's more statutory. Under the guidelines, the old guidelines, you had a sentencing range. And so,
if we find that the trial court's findings are vague, at the very least, we need to remand for clarification.
if you find that they're vague,
Yes.
So if you look at the decision in Jeske, Your Honor, I think what you would have to do is, if you're thinking that it's vague under step 1, then you would evaluate it to see if there's any like harmless error component, if you can ascertain the trial court's, an exercise of discretion there. And so I think if you're unclear and you don't think that the trial court properly used its discretion, and there were enough facts to support, based on the charge alone, to warrant the imposition of the sentence, I think then you might be able to do exactly what you said, remand it for clarification. But I think, sorry, Your Honor.
So is it going back to the same judge or a different judge, as Mr. Crawford wants?
I guess that would kind of depend on how the court, would fashion the remedy, to be honest with you, Your Honor.
Is there anything in the record that would, is there anything in the record from the trial court's statements that we should not send it back to the same judge for sentencing?
I think that would, I don't think the court in this case did what the court did in Barnhill, which is that categorical bar. And if you look at, the statutory section, as I was alluding to earlier, section 921, 002 subsection 3, when you have the facially sufficient motion in the facts and circumstances. So in this case, the trial court was aware of the facts and circumstances. And so it wasn't a situation where it had this categorical bar of not departing anytime somebody came before it possessing child pornography.
We don't go with the categorical bar rationale, or if we don't find that is supported by the record. The only basis for reversal would be essentially confusion. Confusion on the trial court's part or our part. In other words, confusion on the trial court's part, which is typical of case law in this area, right? The trial court didn't realize it could depart. Or ours, which is we can't tell whether you knew you could depart.
Correct, and I think it also going
To qualify that question a little better, it's not always a question of whether they knew they could depart or whether they just said, I'm not doing it in these cases.
you don't have, so as far as that broad or that bold of a statement, that you don't have in this particular case, because the trial court, knew its legal basis. It said, the trial court said that, consider the description of the images, and the trial court indicates that it's supposed to apply the law as the legislature branch approved it because they're representatives of our community. In their opinion, the amount of child pornography that you possess, they felt the appropriate penalties according to the guide, well, it should be the criminal punishment code. And score sheets is 532.5 months. And they enacted that as a law. The only way I'm allowed to go below that is if there's a valid basis, or if there's a basis for departure. And the statute clearly outlines when a court, what they should consider and when it's appropriate to impose a departure. And so I don't think that this was an instance where it had a categorical bar to departing. It understood that the legislature authorized it to depart. It just found that it didn't have a valid basis to depart.
I want to shift gears on.
Of course.
Because we ran out of time with Mr. Crawford to talk about his argument about the disproportionate sentence. So
Yes,
I want to talk about that a little bit.
Of course.
You spent time in your brief reminding us all what we knew, that we don't do this in death penalty cases anymore.
Correct.
I'm satisfied that's not what he's asking, so I don't want to waste our time.
Of course.
Go there. What I want to do is focus on Solon versus Helm.
Yes.
Which is a federal case.
It is.
It talks basically about the sentence being proportional to the crime. So this area, we see a lot in court, and we see very harsh sentences for this. It's a reprehensible crime. There's no question about it. Somebody who's looking at child pornography, definitely needs to be dealt with. But we do see these extraordinarily long sentences for not engaging in sexual abuse of children, but for looking at pictures online. And that's, I think, Mr. Crawford's point. There's a developing body of literature which basically says these people that are looking at this stuff online do not ipso facto graduate to touching. They just don't do that. More often than not, that's all they're going to do. 45 years for looking at dirty pictures of children, which again is a reprehensible crime. That's a long time.
It may be, but it's also the lowest permissible sentence as calculated by the criminal punishment code. So I understand where, there might be, where the court might be considering a disproportionate argument, but the court needs to understand that this was the lowest permissible sentence pursuant to the criminal punishment code. And when if you look at State v. Gabriel, when the lowest permissible sentence exceeds the statutory maximum, the trial court is supposed to impose the lowest permissible sentence unless there's a valid reason to depart. And so the trial court, unless the trial court was presented with that sort of evidence that this is disproportionate, which it was not done, the trial court was never presented evidence that said this is a disproportionate sentence because look at all these different crimes. And this court has specifically cautioned against lumping offenders by category. It's done so in Barnhill, and it did it. I'm sorry, I apologize. Let me rephrase that. It also looked at the lumping in jet ski as well. And what this court said in Barnhill is, this categorical bar of not departing, you're doing that across a broad range of offenders. So basically anybody that comes before the court on a child pornography charge, I am never going to impose this sentence.
It's one judge, you're saying?
Correct. And so
What would be a scenario in which a disproportionate sentence, a crime could be valid, or could be, what would it look like on appeal? Would you be seeing in the record?
That would be very difficult.
Another thing to ask, but I'm asking.
It's a very comprehensive question that I don't think is applicable to CPC sentencing. And the reason I say that is this: as far as the Supreme Court is concerned, they've only referenced the disproportionality in that one single case. If you look at Granby, Florida, there's a whole analysis that the court goes through about disproportionality. And I know they did it in juvenile offenders, but that kind of they came down on a little bit different area. And I know I'm kind of running close on time.
Haven't some of our sister courts commented on this, and whether or not this is cruel and unusual? And Stevens discussed that these types of sentences aren't cruel and unusual.
It may be, Your Honor. I'm not familiar with, I know the case law as far as disproportionality is kind of all over, and the Supreme Court kind of recognized that in Granby, Florida, that the case law supporting a proportionality or a disproportionate sentence is kind of all over the place. They said that they never really applied it consistently, because the only time that they found a disproportionate sentence was in that, what was it, Selm v. Helm case, and they said that they've upheld long sentences for petty crimes in and other circumstances. So I don't think that this runs into the Eighth Amendment challenge. And the reason I say that is because this is not a situation, I know, if Your Honors, I know I'm getting closer over time.
Just finish.
Okay. And so, Your Honor, this is not a situation where the trial court is departing from the criminal punishment code. It's not stacking these sentences, not, saying I'm going to run 15 years consecutive to 15 years on all 40 counts. It's saying the lowest permissible sentence as provided by the criminal punishment code is this sentence. I need to impose that sentence, or I need to find a valid basis to depart. And because, Your Honor, I think the trial court followed the law, it applied the correct law, and there's factual support in the record, I would submit this court may affirm the judgment. Thank you.
Crawford, we have 5 minutes.
Yes, Your Honor. And I will touch briefly on the first issue, and then I'll move to the second. Essentially, what the case law in this circuit, as well as the other appellate circuits within Florida hold, is that this court can't exactly figure out what the trial court did, that remand is appropriate. That's exactly what happened here. I'd also submit that the court made a finding that there wasn't an adequate factual support, because specifically in the part of the record that the state references, she said there wasn't sufficient evidence of post-traumatic stress disorder. That ignores the other diagnoses that Dr. Ringy made, which was severe depression and anxiety disorder with panic attacks. So to the extent that the court made that specific finding, it's not supported by competent substantial evidence. Turning to the second issue, unless there's any other questions about the first issue. The second issue does not involve, Judge Morris, as you noted, a proportionality analysis according to the death penalty. That's something that's done by the Florida Supreme Court and has since been overruled. What the Eighth Amendment challenge is, according to the United States Supreme Court Solem case, is that under the Eighth Amendment, there are certain sentences that are grossly disproportionate to the crime charged. And I think everyone would agree that child pornography is certainly reprehensible. The question becomes, in looking at that analysis, there's three prongs for this court to look at. Number one, the gravity of the offense and the harshness of the penalty. What we know is that Mr. Maniac is a 54-year-old man who has no prior felony record other than a misdemeanor DUI from 25 years ago. 25 family members testified at the sentencing hearing itself to say what a good person that he was. There's no evidence that he sexually molested any children whatsoever. And what is especially telling in review of the other Florida statutes is that Mr. Maniac could have actually killed a child, aggravated manslaughter of a child, and received.
Is this a matter that we need to decide, or is this a legislative issue? I mean, they put that each picture is a count.
Correct.
Have any of the district courts found sentences like these to be cruel and unusual under the Eighth?
No.
And in fact, some of them have found that they weren't. Is that right?
That is correct, Judge Smith.
But somebody has to be first, right?
Someone's got to be first. And the courts have specifically said, in fact, this court has specifically said in cases that there still is an Eighth Amendment challenge. Judge Smith, what you can't say is just because another district court of appeal has found that this sentence was upheld, we should do that here. That's not what the United States Supreme Court says. The United States Supreme Court says each individual case must be judged on the specific facts and circumstances of the case.
Where is that? In Solon v. Helm?
Correct. And I'm
But
cited
in
within
this
the brief.
case, had the trial judge said, I find there's a basis to depart, I exercise, point two, I exercise my discretion not to depart, and I impose the lowest sentence under the criminal punishment code, you wouldn't be having this conversation, would you?
On the Eighth Amendment, I would, yes.
Well, but on the Eighth Amendment, doesn't that presuppose that, this prong two is totally discretionary.
Correct.
So if prong two basically has been met and the lowest possible sentence under the code has been in place, it's a little harder argument, isn't it?
Whether or not the court imposed its discretion and provided the lowest permissible sentence, it still does not do away with the Eighth Amendment constitutional argument, the federal argument, specifically under Solon versus Helm, that a 45-year possessory offense without any child molestation on the defendant's part, with no prior felony record, especially in comparison with other sentences from Sarasota on this specific issue. I cited and I also filed a 3800 motion on this, in which there are 6 other defendants who are almost identically charged who received substantially less sentences than Mr. Banyak, and that's a consideration under one of the prongs on Solon versus Helm. Furthermore, it would be a sentence like this, which is a life sentence. For a 54-year-old man, a 45-year sentence is a de facto life sentence.
Mr. Crawford, you're out of time, so just move.
I will wrap it up, Your Honor. But it is a it's a possessory offense. Someone who is charged with killing a child or molesting a child and actually do that could receive a much, much, much lower sentence than Mr. Manyak. I'd respectfully ask the court to reverse and remand on both issues for resentencing before a different judge.
It's a very interesting case, and you both did an excellent job in briefing and arguing. It was a pleasure to watch you work.
Thank you.
Is Betty Baxter, the estate of Brian Baxter versus Mark Morelli and